Maintaining a client's confidentiality is rooted in the ethical code that applies to social workers and clinicians. This ethical responsibility to maintain a client's privacy and confidentiality becomes obscured when that client poses an imminent threat to themselves or others. In 1974, the blurred lines between ethics and law made it to the California Supreme Court with the case of Tarasoff versus the Regents of the University of California. The Tarasoff case involved Tatiana Tarasoff, who was murdered by Prasenjit Padar. And Padar was an acquaintance of Tarasoff, and during one of Padar's therapy sessions, he told his therapist, Dr. Lawrence Moore, that he intended to kill Tatiana Tarasoff. Padar was considered dangerous and temporarily confined, but then shortly after he was released, and unfortunately he followed through with his threats to kill Tarasoff. Tatiana's parents sued Dr. Lawrence Moore and everyone else at the University of California that was aware of Padar's intentions because none of them warned their daughter, which could have potentially saved her life. The California Supreme Court decision made it standard for practitioners to breach confidentiality and their duty to warn others about the possible danger their client poses. In the majority decision, it was determined that protective privilege ends where public peril begins. This newfound concept of a duty to warn had major impacts on the legal requirements for clinicians and their client's sense of confidentiality. In 1980, the case of Thompson versus the County of Alameda further clarified certain factors concerning a clinician's duty to warn. The court ruled that the threat must be specific in addition to being an imminent threat towards a readily identifiable victim. And in 2003, Reamer developed 4 guidelines that clinicians should consider when balancing their obligation of confidentiality and their duty to warn. First, the social worker must have evidence that the client poses a threat of violence to a third party. Second, the social worker should have evidence that the violent act is foreseeable. Third, the social worker should have evidence that the violent act is imminent. And finally, a practitioner must be able to identify the probable victim. The disclosure of confidential information against a client's wishes should not occur unless the social worker has specific information about the client's apparent intent. The law and ethics collided in these cases because these social workers and clinicians are obliged to walk a very fine line in order to ethically protect their patients' privacy while also fulfilling their legal duty to warn possible victims who face impending harm at the hands of their client. For many practitioners, this collision of law and ethics can be hard to navigate, so it is suggested that unsure clinicians should carefully assess and consult with a supervisor in order to develop an appropriate plan of action.